Before we even get into the courtroom chaos you're about to witness, let me set the stage. Because this case is a perfect storm of broken relationships, misunderstood legal boundaries, and courtroom reality checks. We've got bond conditions, alleged violations, custody confusion, and a judge who is not here to play referee for personal disputes. One emotional confrontation turns into a legal lesson real fast, and what starts as frustration quickly spirals into warnings about jail time, additional charges, and serious consequences. The big question is this: where does personal responsibility end? And where does the justice system draw the line? Stay locked in, because every word matters in this courtroom.
Make sure that you pay attention to your bond conditions. You've been instructed in your bond conditions to not have contact with a particular person or persons. Please make sure that you do not have contact with those persons. If you do, even if they contact with you, if you have contact with them, you're subjecting yourself to having your bond revoked. You could spend the remainder of that time in jail. And you could also be charged with misdemeanors or felonies. Okay, so please be mindful of that. You're free to go at this time.
Your Honor, the thing is, on the bond contact, it says that
Miss Benz,
he's taking my child now. He's taking my child and use my child against me because of this case. Like, what am I supposed to do?
Okay, Miss Benz, I don't know y'all's relationship. Are y'all married?
No, we're not. But he has illegally taken my child away from me for 3 years.
Miss Benz, then you need to go through the superior court that deals with family issues, or you need to go to jail to the police and swear out a warrant for interference with custody. If you had custody. Now, if he's an equal parent, you might have to figure something else out.
My child is not legitimized in the state of Georgia.
Okay, then you need to go to the police.
Mr. Boston, I wouldn't say anything.
Boston, Ben, stop it. I'm not here for y'all for this. Y'all see all this foolishness where you having babies with people and we're not married and we don't know what our legal status is. I'm not your attorney. What I'm telling you is, if you need to go figure something out, then go to the police or go to superior court. Family law is not what I do. Y'all getting into these situations with no clue about the legal ramifications of just having a baby with somebody. Marriage, that's pretty cut and dry. You can figure that out. But when you're just having a baby with somebody, then you don't know what the legal ramifications are. You need to go to the police if you feel like he's interfered with custody. You need to go to superior court if you feel like you need to have custody and legitimation straightened out. Neither which do I do. Whew, a lot. All right, so Mr. Allen, your attorney has announced you're ready for trial, so you're free to go at this time. Mr. Boston, your attorney has announced that you're ready for trial. You're free to go at this time.
Thank you so much, Your Honor.
All right. Coleman, I don't know that they appeared, but because there was a waiver, but their trial calendar, you're free to go at this time.
So am I free to go, Your Honor?
Miss Benz, you can do whatever you want to. I don't control your presence here. You're a witness for the state. I told you, if you have issues, contact Miss Hemphill.
What's the point of you being a judge and you have conditions over his bond, and on the bond conditions it says that he's not supposed to be around me or my children, and this man has taken my child, and knowing that he's not supposed to be around my child?
Ma'am, then that's why you call the police and show them the bond conditions. They don't know where he is
to even get my son. We don't
have ma'am, I don't know where he is. Ma'am, how would I know where he is?
This is not fair. Y'all supposed to be the justice system, and
I'm not the police, Miss Benz. Miss Benz, I'm not the police. What I do right here, sitting in a chair, looking out over the courtroom. I'm not the police. I'm not gonna go track down Mr. Boston. That's not my job.
That's all right. My attorney will be in contact. Thank you. You have a great day, Judge.
He don't need to contact me.
No, my attorney will be in contact with his attorney.
All right. Well, y'all work that out. All right. So, all right, ladies and gentlemen, I feel for Miss Benz, but I'm just gonna make a public service announcement. Judges don't do everything. We don't do what the police do. We don't do everything. So what I was trying to explain to her is, I don't deal with custody, and all of those things. The only thing I do is I stop violence from happening between people. And if you have a bond condition that comes up from magistrate court, that determines that we're going to keep people apart, so that there's no violence until the case is resolved. I don't get into whether somebody can see their kids or not, or legitimation, or because that's stuff that y'all already should figure out. If y'all are having children with somebody, you already know, you or should know the legal ramifications of it. I can't, there's nothing I can do about going to get her child from Mr. Boston. That is not my role. She can go to the police, she can go to Superior Court, but I don't control those dynamics between people. I know my role, and I'm going to stay in my lane.
This is the moment where courtroom reality collides with public expectation. What the judge is clearly explaining, and what many people misunderstand, is that bond conditions are about preventing violence, not solving custody disputes. The judge cannot retrieve a child, enforce family court orders, or investigate allegations. That authority belongs to law enforcement and Superior Court. Emotionally, it feels unfair, but legally, the judge is absolutely correct. This is also a critical reminder. Violating bond conditions, even indirectly, can land someone right back in jail. So here's the real question for you watching. If you were in her position, would you follow the legal route, or would frustration push you to cross a line that could hurt your case even more?
But what I'm not going to do is have somebody tell me that I'm not doing what I'm supposed to do because they don't know how to reach their baby's father.
I do have one announcement.
Yes, ma'am.
Mr. Childs, so two things. One, we discovered a conflict, and then two, he said that he wanted to be pro se anyways, like from the beginning. So I'm not sure how we ended up entering a plea with him. However, he did explain to me that he would like to represent himself.
Mr. Childs, what do you say?
I've been trying to represent myself since day one. Only reason why we couldn't dismiss this faster because we was doing like video call during COVID, so they couldn't come to a courthouse, and I was injured. So that's only like prolonged. We were trying to finish this from.
Okay, so Mr. Childs, let me explain something. The reason you have an attorney is so you don't get yourself in more trouble. Listen to me carefully. Just listen, okay? I've been doing this a minute longer than you have. You got one case. I've had thousands. Listen to me. You saying no, you don't want to hear what I have to say.
I'm listening to you.
Okay, what I'm saying to you is, number one, if you're telling me the witness is not coming to court, then that suggests to me that you violated your bond conditions by talking. Listen to me now, hear me. Okay. Just hear what I'm saying, and the reason why I don't like for a lot of people to represent themselves. If you want to do it, that's fine, but I caution you about it. And they allow us to caution you about it because it's such a big risk. Number one, if you tell me you know what the main witness is going to do, then that suggests to me that you've had contact with them. And if you have contact with somebody in violation of your bond conditions, your bond can be revoked. You can be charged with additional misdemeanors or felonies. Number one. Number two, when you represent yourself, if you represent yourself at trial, then there are certain rules to how you get evidence into the record of the court. You may have something that needs to come before the court, but it can't come before me because you don't know the rule about how to get it in.
We're not trying to play a game.
No, it's not a game. There are rules to what we do. And if you don't do it right, you may not be able to get it before the court.
Mr. Childs, don't talk while the judge is talking, please.
I have respect for you. Don't represent.
She hasn't allowed us to withdraw yet, so we do until she rules that way.
Right.
So I can let Ms. Hahn withdraw because she says there's a conflict, but if you want to go forward by yourself, I need to tell you that there's some risk with that. And I also need to tell you that if you were convicted, let me explain. Each of these cases can be punishable. Each of these charges can be punishable by up to 12 months in jail, a $5,000 fine, or both. And I could run each charge consecutive, which means you could get on the first case 2023 CR 02430, you could get 1, 2, 3, 4 years straight to serve. So maybe one of them would merge, so 3 years straight. The second one, 1, 2, 3, 4, maybe one of them merges, you could get 2 to 3 years straight.
Honestly, you're my judge. You're the one that's going to decide what's going to happen, correct?
Yeah, but not, wait, look, I decide if it's a bench warrant and I hear both, I mean, if it's a bench trial and I hear both sides. If it's a jury trial, the jury will decide, and I just decide on sentence.
You tell me that it's not a game. You tell me these rules, and see, that's what I'm saying. They tell me this one. You all right? I'm telling you, everybody that's on the chessboard is here, ready to move. The queen is here. The king is here. You also have Bishop. She's ready to, everybody in position. They want to make their decision. You all are just in the way. The players are here. We're ready to speak on how we want to speak. I understand you saying this and that and this to step in, but we all, the charges want to be dropped. So it's like,
well, how you know? See, this is where you get into trouble, because how you know the victim wants the charge dropped? Because that means you've been communicating with them. I'm
not saying, ma'am, that doesn't matter.
It does matter. If you violate a court order, it matters.
Anything, Your Honor.
If you violate a court order, it matters.
Look, listen, I didn't violate anything. I spent my time in jail,
For the
and I was
record,
released.
Your Honor,
I didn't have a burn. I didn't burn.
advise that I'm just asking Mr. Childs to not
All I'm
speak.
saying,
Hey, get me a copy of Mr. Childs' bond conditions on both his cases, please.
I didn't burn out, Your Honor.
Get me a copy of the bond conditions on both Mr. Childs' cases, please.
And even if let's say I burn it out, why are we still moving forward? The screen went black.
Because you don't get to make that decision, Mr. Childs.
I understand whoever makes the decision, people that, you guys shouldn't even be able to make the decision. People that call the police, people that are involved, people that don't want the police involved anymore.
You know why we don't pay attention to that anymore? Because people used to get beat down, and then for various reasons they say, oh, please drop the charges because I need him to pay these bills, or I need him to do this, or I need him to do that. And then the police would drop the charges, and then that person would go back and beat them again. So that's why we don't let y'all resolve it. Because if you could have resolved it, you wouldn't be here in the first place. You wouldn't be charged with two charges, two cases of violence.
I just need common sense to play into this situation. I feel like anybody with common sense.
Common sense means you wouldn't have been charged with 2 counts of battery on 2 different cases.
Life is full of all of that, you know what I'm saying? But you still see through your mistake. So
okay, so to cut this short, I can appoint you another attorney, but the case is not being dismissed. I can appoint you another attorney if you want, but the case is not going to be dismissed.
I want to ask for this to be dismissed.
It's not going to be dismissed, I just said.
That's what I don't want to, ego to play a role. I know you have, authority.
Mr. Childs, what did I just say? I said no.
Mr. Childs, I'm about to press.
I said no. So do you want a jury trial or a bench trial? Let me know.
I don't understand y'all rules. I don't even understand the terminology. This is not my field. This is not my preference.
Which is why you had an attorney, Mr. Childs, and I can give you another one.
I don't understand what's going on here. I don't know what a bench trial, I don't know what a trial. I just want to let this go.
Like it's not going. That's not going to happen.
We want y'all to stay out of our life.
Well, then somebody need to stop calling the police. That's not going to happen. So you got 2 cases, Mr. Childs. Do you need another attorney?
Yes. That's what I'm saying.
Mr. Childs, yes or no? Do you need another attorney?
I need y'all to just let this situation go.
That's not happening. Do you need another attorney? Okay, go sit down, Mr. Childs.
But if this is going to
Deputy Jones, Mr. Childs may need some time behind the door because he keeps talking to me and I keep trying to tell him, go sit down somewhere. Today's not the day. Have a seat. Thank you.
Your Honor, it is my understanding that the Mr. Phillips that is present is actually the father of my client in this case. We had apparently his email address. I had told the son to also appear, but I don't currently see him.
Mr. Phillips, where's your son?
In Charlotte, North Carolina.
Okay, why is he in Charlotte and why couldn't he appear by video?
I don't think he has a computer. But my understanding is that his probation officer told him that his case had expired.
This is a new case. He doesn't have a probation for this case. It's still open.
I don't understand why he has to go to court.
Okay, so Mr. Frank Harrison Phillips has a 2022 driving under the influence case. I don't know what the bond is for anything because this case is still open. He hasn't been before a judge to be sentenced. He hasn't had a trial.
He served 30 days in jail. I did not post bond for him.
That does not resolve a case. That just means you couldn't bond out for pretrial detention. It doesn't mean your case is resolved.
Well, yes,
bond and a sentence are different.
Yes, but as far as information I received from him, is that he spent the 30 days in jail and then he was on probation for a year. And his probation officer, who was Rebecca Chang, said that told him his case had expired and it was no longer an issue. And so therefore he went on with his life, not realizing he had any more obligations.
There's a couple of things wrong with that. First of all, that is possible, but that would have been for a different case. A 2022 case hasn't even come up for trial yet, and it's been less than a year since 2022. So if he had a 2022 case, he wouldn't have already been served 30 days in jail, been sentenced, and served a year on probation.
Yes, ma'am. So I think what you're telling me is that this is a second case. His first.
Yes, ma'am. Yes, sir. That's what I'm telling you. And your son needs to be here.
Well, I don't think he understands that he had a second case. As far as he was concerned, his only case was took place on November 13th, 2021.
That's not my issue because the notice to appear would have said that this is a 2022 case.
Yes, ma'am.
And I didn't excuse him.
Yes, I don't think he received that. After he got out of jail, he stayed in Jonesboro for quite some time and then went to We Are Living Proof up at Lawrenceville and then another one in Marietta. And after that, he's moved to Charlotte, North Carolina. I don't believe he ever got any word that there was a second case. I don't know that, but that's in my talking to him, all he knew was about the first case in November of 21.
Okay, so that highlights a couple of things. First of all, he's been given notice, and we are given notice to the last available address that he provided. So if he failed to provide an updated address, that's on him. Second thing is he still has to be here. Even if it was incorrect, out of an abundance of caution, he should have come. But yeah, he's going to get a bench warrant and a bond forfeiture because he's not here.
Yes, ma'am. So I don't understand the bond forfeiture. I never put up any bond, or he didn't have a bond.
On this, it says he put up a bond. That's what I'm telling you. This is an entirely new case.
I guess I'm assuming that the court knows that I just don't believe this happened. He didn't have a car. He wasn't driving.
Mr. Phillips, I can't debate that with you, sir. Your son needed to be here for this calendar call. It's obvious that he has information that you don't have. So at this time, I'm going to issue a bench warrant bond forfeiture, and you can let him know that he needs to contact his attorney at Lister Holton Dennis.
Yes, ma'am. Thank you.
All right, thank you.
This courtroom session ultimately highlights one powerful takeaway. The justice system operates within strict lanes, whether people like it or not. The judge reinforced that bond conditions exist to prevent harm, not to resolve personal or family disputes, and attempting to blur that line only creates more legal exposure. From warnings about bond violations to issuing a bench warrant for failure to appear, the rulings here were about accountability, procedure, and public safety. Emotions ran high, but the law remained clear. Now I want to hear from you. Did the court handle this correctly, or should there be more flexibility in situations like this? And if you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.